Welcome everyone to today's webinar. Thank you for attending. My name is Kieran Richardson. Today's webinar is on the topic pre-appointment debts, who pays, and will be presented by Lavan Legal Partner Joseph Abberton and Solicitor Leona Lam. Before we meet the speakers, I would like to give you a brief overview of today's webinar. If you have any difficulties viewing the presentation, please call Sophie Parker on 0419 946 570. We invite you to ask questions at any time during the presentation. Please use the chat box on your screen to enter your questions. We will respond to as many questions as possible. If you are a legal practitioner and would like to receive CPD points for this webinar, it is important that you remain in attendance and logged on for the duration of the webinar. I'd now like to introduce our speakers. Joe Abberton is a partner in Lavan Legal's Recovery, Insolvency and Reconstruction team in the Commercial Advice and Litigation Group. Before joining Lavan Legal, Joe worked for the former PPB partnership, now McGrath-Nicol, where he attained his CA qualification in a wide range of insolvency appointments. Since joining Lavan Legal, Joe has specialised in insolvency and reconstruction and has worked primarily in advising insolvency practitioners across all aspects of receivership, liquidations and administration. Joe is also a member of the WA Committee of the Insolvency Practitioners Association. Our other presenter for today is Leona Lam, a solicitor who works alongside Joe in the Recovery, Insolvency and Reconstruction team. Thank you for joining us today, Joe and Leona. I'll now hand over to you.
Thank you, Kieran, and thank you to everyone for joining us today for our webinar. Today we're going to be discussing pre-appointment debts and who pays. We'll be discussing this topic from an insolvency context, which is to say that in circumstances where a receiver, voluntary administrator or liquidator is appointed, who is responsible for the pre-appointment liabilities of the insolvent company. Practically speaking, when an insolvency practitioner is appointed to a trading company, there are usually a number of contracts with the company that are in place. The insolvency practitioner's conduct in relation to these pre-appointment contracts can affect whether the insolvency practitioner is liable for the payment of the debts or whether the debt is one owed by the company. Conversely, the manner in which insolvency practitioners conduct themselves can determine whether a creditor can seek payment of a debt from the insolvency practitioner personally, or whether they will be an unsecured creditor of the company and have to wait for a payment from the assets of that insolvent company. Our discussion today will briefly canvass some of the legal and statutory principles before exploring some hypothetical scenarios to examine how these principles operate. So without further ado, I will pass you over to my co-presenter, Leona Lam, who will get things underway. Leona?
Thank you, Joe. I'm also glad to be here today speaking on this topic. Before we move on to the hypotheticals, let's just take a short amount of time to go through the law in this regard. Under the general law, receivers and administrators are not personally liable for debts incurred under pre-appointment contracts. However, debts arising from pre-appointment contracts may become personal liabilities for administrators and receivers if the administrator or receiver has assumed liability with a positive act or adopted the pre-contractual liability. Also, pursuant to sections 419, 419A, 443A, and 443B of the Corps Act. So a little bit more about 443A and 419 of the Act. Section 443A of the Act renders administrators liable for debts incurred in the performance or exercise of any functions and powers as an administrator. Similarly, Section 419 of the Act renders receivers liable for debts incurred by the receiver in the course of the receivership. While a receiver or administrator may be indemnified in respect of any liability that they incur, they cannot contract out of the statutory liability under Sections 443A and 419. Sections 443A and 419 are relevant to pre-appointment contracts if, upon the appointment, the receiver or administrator allowed a pre-appointment contract to continue and a liability subsequently arose under the pre-appointment contract. In those circumstances, the court will consider whether any liability would have been incurred without the receiver or administrator before determining whether personal liability is triggered. The rationale behind Sections 443A and 419 is to protect third parties, the subject of the pre-appointment contract, such as creditors and service providers, because in an insolvency situation, the company is unlikely to have sufficient assets to meet any pre-appointment debt obligation. If a receiver or administrator is free to incur costs on behalf of the company without incurring any personal liability, any debts incurred by the receiver or administrator will become unsecured debts of the company. So that's a brief overview of the law. I'll hand you back over to Joe. We'll go through one of the hypothetical examples we have for you today.
Thanks, Leona. The first hypothetical that we have today is High-Class Apartments. High-Class Apartments Proprietary Limited took out a loan in the amount of $500 million with the Bank of Dreams to construct a 6-star luxury timeshare apartment complex in Geraldton, Western Australia. As security for its obligations under the loan agreement, High Class granted the Bank of Dreams a mortgage over the development property and a security interest over all of its assets and undertakings. The term of the loan was for a period expiring on 30 September 2013. In order to repay its loan to the Bank of Dreams, High Class proceeded to sell a number of the timeshare apartments. However, it became evident from early on in the sales and marketing campaign that High Class was not going to be able to sell enough apartments in order to repay the bank, as the Geraldton community did not seem to support the project and there were limited surrounding attractions to generate interest from overseas investors. As a result, when the term of the loan expired, the Bank of Dreams appointed receivers and managers to all of High Class assets and undertakings. As part of a review of High Class's books and records, the receivers became aware of a number of pre-appointment contracts. The first contract was between High Class and a Mr. Justin Married for the purchase of the luxurious honeymoon suite. The purchase price of the apartment was $3.5 million, and Mr. Justin Married had paid a deposit of $350,000. The honeymoon suite had a market value, according to a recent valuation from CBRE, of $5 million.
So, Joe, what do you think? Are the receivers obligated to complete the contract with Mr. Justin Married?
Well, I think that's an interesting question, Leona. And typically what will happen in these situations is that receivers will look at a pre-appointment contract and will consider whether or not they have the ability to repudiate or look at setting that particular contract aside. However, in this situation, because Mr. Married has paid a deposit in respect of the purchase of the honeymoon suite, Mr. Married has an equitable interest in the property. Receivers, when they are appointed, take their appointment subject to all prior equities. So in this situation, because the receivers were appointed after the contract was entered into between High Class and Mr. Married, the receivers would be, absent some other steps, obligated to complete the contract with Mr. Married. Okay, so continuing on, the receivers contacted Mr. Married and said that he needed to increase his offer by a further $1.5 million in order to bring the value of the offer in accordance with the offer from the evaluation from CBRE. Mr. Married then increased his offer to $5 million and the receivers proceeded to effect settlement of the property. 2 weeks after settlement, Mr. Married wrote to the receivers demanding the amount of $4 million as compensation for the loss and damage he had suffered as a result of various misrepresentations that were made to him regarding the size of the spa the master bedroom, in that Mr. Married was told that the bed would be round and not oval shaped, and that he couldn't get an oval shaped bed from a bed supplier, and also that the amount of mirrors in the main bedroom, Mr. Married was told that there would be floor to ceiling mirrors, and in fact there were very limited mirrors in the apartment.
So would the receivers be liable for the loss and damage suffered by Mr. Justin Married as a result of those pre-appointment representations?
In assessing the answer to this question, one of the things that Leona discussed in the introduction and that needs to be looked at from a receiver's perspective is, has the receivers adopted the pre-appointment contract? In circumstances where a receiver or an administrator has adopted a pre-appointment contract, then it's more likely than not that they will be liable for performance of that particular contract. Adopting a contract is something that needs to be looked at in view of the specific facts of the case. In this particular example, the receivers have gone to Mr. Married and presented him with a counter offer. Mr. Married has then accepted that offer, and whilst in totality it may be viewed as a variation to the contract, in all likelihood the variation to the contract is one which would render the receivers personally liable to perform the contract as a result of them adopting the contract. Now, typically speaking, in circumstances where contracts have been negotiated by other parties, and in this case, based on the facts, it's relatively safe to assume that the directors of High Class or whoever sold Mr. Married the property made a number of representations to Mr. Married about the shape of the bed or the mirrors in the apartment, that Mr. Married relied on those particular representations. Whilst the receivers were not party to those representations more likely than not formed part of the contract, and as a result the receivers would likely be personally liable for those representations. One of the key aspects that receivers need to consider when they are looking at varying sales contracts not only is whether they are going to adopt those contracts, but whether they insert specific conditions into the contract so that they can protect themselves from personal liability. Another issue that receivers will face when they look at varying contracts, specifically in relation to price, is whether or not they've complied with their Section 420A obligations. Now, continuing the hypothetical, what we want to do is rewind 2 weeks, and instead of renegotiating the contract with Mr. Married, the receivers instead seek legal advice as to whether they can set the contract aside.
So what happens then? Can the contract be set aside? If so, what happens to the deposit then?
The first question that we looked at in this hypothetical was whether the receivers were compelled to complete the contract. Whilst technically speaking the answer that we gave was that the receivers would be compelled to complete the contract, that ignores certain practical and commercial realities, namely that a mortgagee, in this case the Bank of Dreams, is not required to discharge its mortgage simply because there's a contract in place. So, from a practical perspective, while the receivers, who had a subsequent equitable interest in that they took their appointment subject to all prior equities, would not be in a position to set the contract aside, it is likely or possible that the Bank of Dreams, as a mortgagee who had a prior registered legal interest, would be able to take some steps to set the contract aside. In those circumstances, if the contract was set aside, it would depend on the terms of the contract as to whether or not the deposit would be refundable. Ordinarily, in most sales contracts, the deposit will be refundable in circumstances where a contract is terminated. However, it may have been the case in some contracts that deposits or part payment of deposits were non-refundable in relation to due diligence periods or extensions of time. Okay, the second contract that the receivers came across was in respect of the Ocean View apartment, and that contract was a contract between High Class Investments and a Mr. C. Farrer for the purchase of a luxury Ocean View apartment. The purchase price was $2 million and no deposit was paid by Mr. C. Farrer. The luxury Ocean apartment had a market value, according to a valuation from CBRE, of $1.8 million.
So what about this one? Can we set this one aside? Can we set this contract aside?
This is probably a different situation here, Leona, and the first thing that we would want to look at is, well, the purchase price is $2 million and the market value is only $1.8 million. So commercially speaking, one has to wonder why the receivers would want to set the pre-appointment contract aside in the first instance. However, saying that, because there's no actual deposit that has been paid, there is a strong inference that can be drawn from that to suggest that Mr. C. Farrer does not have an equitable interest in the property. He's only a contractor, and the contract may be able to be set aside by the receiver. In any event, for the reasons that we discussed in relation to the contract with Mr. Married, the mortgagee, the Bank of Dreams, is likely to have the power to refuse to discharge its mortgage and set the contract aside in any event. So, instead of setting the contract aside, the receivers proceed to complete the contract. 2 weeks after settlement, Mr. C. Farrer asks the receiver how they are progressing with the construction of his private jetty. The receivers rush back to their office and review the contract. They cannot find any clause that requires High Class to construct a private jetty for Mr. C. Farrer. They contact Mr. C. Farrer and ask him to provide a copy of the contract. Mr. C. Farrer provides the receivers with a contract that includes a provision that the receivers construct Mr. C. Farrer a private jetty for his Ocean View apartment.
What happens to the jetty then? Are the receivers liable to pay the cost of completing the private jetty? But what if the assets of High Class are not sufficient? Will the receivers be personally liable for that cost?
Well, I think first off, Mr. C. Farrer is doing pretty well to get a private jetty with his apartment. But this is a really interesting scenario, and it's interesting in the sense that we have a pre-appointment contract which the receivers have not altered and they have not varied. They've only proceeded to effect settlement of that contract. One of the things that the receivers would have to do in assessing the situation is work out which of the two contracts was legitimate. If it was the case that the contract that required High Class to build the private jetty was in fact the actual contract and was the legitimate contract, then it would seem likely that the receivers are going to be required to complete the private jetty. And the reasons that they're going to be required to complete construction of the private jetty is that it was a term of the contract where the receivers received the purchase price and settled. That's to say that simply because a pre-appointment contract requires a payment on a certain date, if there is not performance of those particular obligations under the contract, then the receivers cannot require the payment pursuant to that contract. So in this case, unfortunately for the receivers, it would seem as though they're going to have to construct the private jetty. Now, in terms of assessing the assets of High Class and working out whether they're going to be personally liable or not, I think that one of the things that the receivers would probably have to do in this example is work out exactly what it's going to cost to construct a private jetty. Do you have any idea what that is these days, Leona?
I have no clue. Certainly nowhere rich enough to think about a private jetty.
Yeah, I think I don't really know how much it's going to cost to construct a private jetty. But if we were to assume that the jetty was going to cost more than $4 million or more than the $2 million that Mr. C. Farrer paid for the apartment, then perhaps one of the things that the receivers might look to do is somehow unwind the contract so that they didn't have to complete the jetty. Alternatively, if the cost of constructing the jetty, and as I'm reliably informed by other people, which would be significantly less than the $2 million, the receivers would have to pay that money and would probably have to pay it from the proceeds of the particular sale. The receivers would not ordinarily be personally liable to pay these amounts and would look to the assets of high-class investments in the first instance. Okay, next example. The receivers also became aware of a contract between High Class and a Miss Ivana Relaxalot for the purchase of a deluxe spa apartment. The purchase price was $3 million, and Miss Ivana Relaxalot paid a deposit of $450,000. The deluxe spa apartment had a market value, according to a valuation from CBRE, of $2.9 million.
Does Ms. Relaxalot have any rights to compel the receivers to complete pursuant to this contract?
Well, yeah, I think we've covered that specific question off with our Mr. Justin married example, and that is to say that Miss Relaxalot, as someone who has paid a deposit, has an equitable interest in the property, and Miss Relaxalot has various options available to her to attempt to compel the completion of that particular contract. So I would say yes, and those rights include seeking an order for specific performance, and by specific performance we mean making an application to court or an order that the court compel completion of the contract. In this case, the order would be that the seller, High Class Investments, and its receiver completes the sale of the deluxe spa apartment to Miss Relaxalot. In any event, the receivers decide not to complete pursuant to the contract with Miss Relaxalot, as they recently received an offer from Mr. Over the Top in the amount of $4.5 million for the deluxe spa apartment. The receivers instead decide to accept Mr. Over the Top's offer. The receivers advise Miss Relaxalot that they will not proceed with her offer. Miss Relaxalot then commences proceedings against the receivers, seeking an order for specific performance of the contract.
So what happens then if Ms. Relaxalot has an equitable interest and she's successful in her application for specific performance, compelling the receiver to complete the contract? What do we do with Mr. Over the Top? What if he wants loss and damages from the receivers?
Well, the position with Mr. Over the Top will very much depend upon the terms and conditions that are in the sale contract with the receivers. One of the things that we always advise receivers and administrators and other insolvency practitioners to include in sale contracts is various terms and conditions that do not render them personally liable in circumstances where they can't complete a contract if they're prevented from doing so by order of the court, or if, for example, a caveat over the property prevented settlement from occurring. In this case, if they had conditions of those kinds in the contract, then it's likely that they're not going to be personally liable to or for any loss and damage suffered by Mr. Over the Top. If they didn't have those conditions, then it is quite possible that the receivers will be liable as a result of the fact that they entered into the contract in circumstances where they knew the property was already contracted to Miss Relaxalot. In saying that, it's difficult on the facts that we've got in front of us to work out exactly what that loss and damage that Mr. Over the Top would suffer. But perhaps it could be things like the fact that he'd committed money in terms of a deposit. There could be some potential opportunity cost that he would say arose as a result of the fact that he pursued this investment and not other investments. But again, we probably would need some more facts to look at that one. So if Miss Relaxalot is not successful in obtaining an order for specific performance of her contract, and instead she receives an award of damages in her favour.
So then what do we do with Miss Relax-A-Lot? Will the receivers be liable for the loss and damage suffered by her?
I think in this case it comes back to the question as to whether or not the receivers have actually adopted the pre-appointment contract. Certainly on the facts of this case, there's nothing that the receivers have done, no positive act to signify to Miss Relax-A-Lot that they were going to accept the contract. So in those circumstances, it would seem to be the case that Miss Relax-A-Lot would be able to recover the loss and damage that she has suffered and that she has been awarded by the court from the company. It may be a very different state of affairs in relation to the costs of her proceedings. Certainly if the receivers participated in those proceedings and actively opposed the orders that Miss Relax-A-Lot sought. So on that note, Leona, I think we might leave our high-class investments hypothetical, and I might pass over to you for second hypothetical.
Sure, thank you, Joe. The second hypothetical we have is called BVG. BVG is a luxury brand which sells full leather handbags and leather accessories. The BVG shop occupies a two-story premises with an interior spiral staircase in the most prominent, glamorous shopping mall in the heart of the city centre. This premises was leased from Rodeo Drive Shop Front Proprietary Limited. BVG recently announced that its latest line of handbags will be launched in Australia on the 1st of October 2013. There is much anticipation for the new launch because one of the handbags in the new line, the crystal encrusted version, was recently used by Jennifer Aniston in her new recent Hollywood blockbuster, My Bag and Me. In one of the key scenes in the movie, Jennifer steps out of her love interest's awesome Maserati. To reap the full benefits of their marketing campaign, BVG decided to rent a Maserati, place it in the center of their shop upon a rotating platform together with the handbag. On 1st of October 2013, there was a chaos of women rushing into the shop of BVG trying to purchase the crystal encrusted handbag, which, as you can imagine, had a limited release of only 200 in Australia. Nobody knew what fueled the shoppers' aggression for the handbags. In any event, amongst the chaos, the spiral staircase suffered a few scratches and a handrail snapped. The crazy shoppers did not spare the Maserati. There were many attempts by the shoppers to reenact the famous scene in the Hollywood blockbuster movie, and the car suffered some scratches and dents. 1 week later, the Daily Gossip tabloid announced that the dye used in the leather of BVG's handbag contained a toxin, the prolonged exposure of which can be carcinogenic, and BVG immediately recalled all their handbags. However, its reputation suffered such a great loss that sales plummeted. Matters took a turn for the worse when BVG's rival, CTR, launched their line of handbags, which was marketed by Angelina Jolie, Brad Pitt, and a diamond-encrusted Bugatti Veyron. BVG can no longer meet their debt obligations to its Bank of Stars, and owed Rodeo Shop 3 months of rent. It is also behind in its payments to the Maserati. The Bank of Stars then enforced its charge over BVG by appointing a receiver and manager. The appointment extended to all of BVG's assets and undertakings, including its lease with Rodeo Shops and the leased Maserati.
Sorry to interrupt, Leona, but we've just had a question come through that says, is this actually a hypothetical, or did this really happen? Jennifer Aniston and My Bag and Me?
I don't think there's a movie called My Bag and Me with Jennifer Aniston.
I'm not a fan of Jennifer Aniston movies.
You're not?
Personally, myself, I can't answer that question.
No, it's purely hypothetical. But I do think that there are chaoses of women going into expensive luxury brand shops when there's a special launch of any sort of handbag used in the Hollywood blockbuster movie.
So it's a real hypothetical.
It's real.
It's a fair question.
It's real. It's totally reasonable and completely can completely happen. So we continue. After the receiver's appointment, the receivers decided to visit the shop. Unfortunately, BVG has a lot of die-hard fans. Upset that their favorite brand will be taken over by a bank, they attack the receivers with mace, fairy floss, and red velvet cupcakes. In the carnage, the front door, which was in the shape of the letter B, was taken out and thrown at the Maserati.
So, Leona, obviously the receivers are very lucky to survive the attack from the red velvet cupcakes and the fairy floss.
Of course.
But now that they've survived the attack, are they going to be liable for the damage of these crazed shoppers that they've done to the door of the shop and also the Maserati?
The damages to the door and the Maserati is something that occurred after the appointment. Pursuant to Section 419 sub 1 of the Corps Act, the receivers will be liable. Once the receiver enters into possession or assumes control of any property, the receiver will be liable for the debts incurred in the course of the receivership in relation to the leased property. Of course, there's also the question of whether or not the receiver took insurance. If there's insurance, your insurance company might cover that. And just in relation to another point, which is Section 419A, in relation to lease agreements, we can also look at whether or not, pursuant to the lease agreement of the Maserati and the property, whether there is a make good provision that requires the tenant to make good the condition of the leased assets. If there is no such provision, then arguably the receivers will not have the obligation to repair or pay damages for the doors. So we move forward. As you said, the receivers are very lucky to survive the attack. They made it into the office premises where they found a manager of rodeo shops waiting for them. He then tells the receivers that BVG owes him 3 months of rent and $15,000 in electricity bills because BVG uses extra bright lights to shine on the crystal-encrusted handbags. He then demands the receivers to pay the outstanding amount now.
So are the receivers required to pay the outstanding amounts immediately, right then, to this relatively aggressive shop manager?
No, as menacing as he may be, you have no obligation as the receiver to pay him immediately because the debts incurred, the 3 months of rent and the $15,000 in electricity bills, are debts that were incurred prior to the appointment and before you took control of the assets.
Okay.
When we move forward, the receivers tell the managers that they will consider their position, but they're a bit shaken up as a result of fairy floss and the red velvet cupcake attack and may need some medical attention. The receivers contacted their lawyers and asked them whether they are required to pay the outstanding amount immediately and whether the receivers have any other rights.
So what do you think about that, Leona?
I think we covered off on the first point that they don't need to pay the amount immediately. But just in relation to whether or not the receivers will have any other rights, under Section 419 capital A of the Corps Act, the receivers will have 7 days of grace period to issue a notice stating whether or not they will continue to occupy the leased premises. If they do, they will be liable for rent going forward and also any amounts that are relating to rent. If the lease agreement of the asset in the first place requires you to pay the other amounts being, for example, electricity. But in terms of the arrears that have accrued, the receiver will still not be liable. So after obtaining legal advice, the receivers inform the manager that they do not intend to pay the amount immediately. As a result, at midnight that evening, the manager of the shop then changes the locks on the shop, and when the receivers arrive the next day, the manager says if they do not pay, he will not open the doors.
So, Leona, is there anything that the receivers could have done to prevent the manager from changing the locks or locking the doors?
Well, to prevent the manager from changing the locks, I think the receivers could have issued the notice confirming that they are occupying, and therefore the landlord will know that they will pay rent going forward. That will deter them from changing the locks. I understand there's also an option for an injunction.
Yeah, let's talk about the injunction in a moment. But what about if the receivers just changed the locks? In any event, they got their own locksmith to go down and re-change the locks on the landlord. What do you think about that?
I think that would just trigger a cascade of lock changing, like a ping-pong match.
Okay. Well, I think that's something that bears some consideration in relation to the injunction application, and that would be an application to potentially restrain the landlord from taking any steps to evict the receivers and the company BVG from the shop premises. But one of the things that's going to be necessary in order to get that type of relief is to demonstrate that there has been some history of threats, or that there is at least some probability that the landlord is going to take those steps to evict the receivers. In this case, it looks like that the landlord went in the middle of the night and conducted a bit of a stealth mission to change the locks. So perhaps in circumstances where we had a history of the landlord trying to change the locks, we would be able to demonstrate to the court that the landlord was trying to shut the company and the receivers out of the premises. Alternatively, and in the ordinary course, we would generally expect there to be some correspondence, either be it in writing or over the phone, between the landlord and the receivers, whereby the landlord made various threats about evicting the receivers and changing the locks. So I think that, and in this case it doesn't appear that that's happened, but usually if that was the case, then it may be that the receivers could get that order restraining the landlord from taking those steps.
Thank you, Joe. Okay, let's move forward. Let's say, just continuing from the hypothetical, it turns out that Wiley Cyrus had entered into a contract with BVG to collect one of the crystal encrusted handbags, but Wiley was turned away as a result of the manager's action. Wiley needed the handbag for a red carpet event that night to celebrate the premiere of a new movie, Hannah Montana Gone Wild. Wiley Cyrus advises the receivers that she will seek loss and damages from them because she could not use the crystal handbag in the red carpet event.
All right, I'm a bit confused by this one, Leona. Didn't we say that the handbag was carcinogenic and that it was going to probably cause Wiley Cyrus some real health issues?
Let's not apply too much logic to analyse why Wiley does what she does nowadays.
Okay.
Let's just accept that she wants the bag for whatever reason.
Well, we'll accept that Wiley wants the bag for her big red carpet premiere, but are the receivers going to be liable for any loss and damage suffered by Wiley?
This question looks more at the repudiation of a pre-appointment contract. Receivers can repudiate a pre-appointment contract if it does not damage the goodwill of the company. So the question becomes whether it will damage the goodwill if whether it will damage the goodwill of BVG if you don't let Wiley Cyrus use the handbag. I think that largely rests on how the public views Wiley nowadays. But in any event, the receivers can no longer perform the contract because they're locked out and have no access to the crystal handbag at all. And on that basis, I do not think that Wiley can have a successful claim against the receivers.
Are you saying that, essentially, Leona, that any advertising is good advertising and that it would be good for BVG's business if pictures of the handbag were taken on the red carpet with Wiley Cyrus?
No, I replied by inserting a comment beforehand saying that it really depends on how you perceive Wiley Cyrus nowadays.
Okay. And does it make it any difference if the contract was a post-appointment contract, in the sense that the contract was with the receivers as opposed to a pre-appointment contract?
It's an interesting question, Joe. You mean a contract that the receivers entered into after they were appointed? Yes,
and I think that one of the aspects here, and what Leona touched on, was that receivers have an obligation not to, in essence, recklessly disregard the goodwill of the company. And in this case, Leona said that it's not the fault, it's through no fault of the receivers that the manager has come in the middle of the night, locked the doors, and prevented the receivers from giving Wiley the handbag. But in circumstances where it was a post-appointment contract and she had paid full price for the handbag and she needed the handbag for the red carpet event, could she then seek loss and damage from the receivers as a result of the fact that she didn't get her handbag on that particular day? And I think that the answer to that question, again, probably turns on the conduct of the receivers. They haven't done anything necessarily wrong. It's difficult to see exactly what loss and damage that Wiley would suffer from not having the handbag, and it probably also depends on the terms and conditions of the particular contract that was entered into between the shop and Wiley Cyrus, which is to say that ordinarily you would expect that there was some ability to delay delivery. So in those circumstances, they're probably not going to be liable unless the receivers actually took some step that prevented the handbag being supplied to Wiley, which doesn't seem to be the case here.
So now let's turn to the Maserati. So later that day, the owners of the Maserati contact the receivers and ask them what they're supposed to do with the car, which is damaged and not being paid for.
Okay, Leona, so what are the issues that the receivers face dealing with the Maserati?
I think first they need to determine whether they will continue leasing the Maserati. On the basis that they're locked out of the shop anyway, I don't see why they will want to continue leasing it.
Okay. Leona, one of the things that you talked about was Section 419 A of the Corporations Act, and you said that that gave the receivers essentially 7 days to decide whether they wanted to adopt the lease or to terminate the lease.
Yes.
And we looked at that in the context of the shop, but also, and perhaps this is just a personal question for me, someone who's always wanted to drive a Maserati, does that mean we just get to drive the Maserati around for the next 7 days and we don't have to pay for it?
I suppose you have to have option. You have 7 days grace period of using the lease asset without paying rent for it.
And we can do as many kilometres as we want. You know, we can. Let's say I wanted to take the girlfriend down and drive down the coast. I could take the Maserati and off we go.
Assume, well, purely on the application of Section 419A, you will have 7 days grace period to do as you wish with the lease asset. But having said that, I'm not quite sure what the terms and conditions of the lease agreement is. I assume that you can't drive kilometres and kilometres with it, and I will assume also that you are supposed to take good care of it.
And what about, in terms of the care aspect, what about fixing all of the defects? So if we decided to, we'd driven the Maserati around for 5 days, we thought we'd had enough, we issued a notice to Maserati and said we're disclaiming the Maserati, come and pick it up. Does that mean we would have to take the Maserati to the panel beaters and get it fixed up, or would we just leave it and they would pick it up?
I think, in terms of the dents and scratches caused by the shoppers, after appointment, you will need, the receivers will be liable to repair those damages, and if the receivers then use it for joyride and damages the car, just pursuant to 419 sub 1, you will be liable to pay.
Okay. And Leona, in terms of issuing the notice pursuant to Section 419A, do you think there's any difference in terms of the receiver's conduct post-issuing that disclaimer? So what I mean, for example, is if on the 6th day the receiver issued the notice, Maserati for some reason didn't come and collect the car and they simply left the car there, the receiver then decided on the 9th day, well, actually I need to quickly pop out and grab some supplies, and they took the Maserati. Do you think that their conduct in taking the Maserati for a drive would have any effect on the disclaimer?
I think so, because pursuant to 419A sub 5, I believe, you will automatically cancel the effect of the notice if you take the car, if you use the car contrary to what you stated in the notice.
Okay. I think that's a really good point to make, which is that it is something that practitioners need to be mindful of, and certainly everyone needs to be mindful of where there has been a disclaimer issued, that the conduct goes in accordance with that particular disclaimer. Okay, so that deals with the hypothetical part of our presentation today. We also have a number of questions that have come through, so we'll just start addressing some of those. And the first question that we've got is, what are the practical ways of ascertaining pre-appointment liabilities before any appointment is actually made? I think in terms of answering this question, it's very much going to depend on the specific type of company and the specific type of appointment that we are looking at. But generally speaking, one of the options that are available to secured creditors in assessing what the likely pre-appointment liabilities of a company are is to appoint an investigative accountant who will go in and do a review of the company's affairs. This review will usually include looking at such things like various contracts, working out whether there's insolvency provisions in those contracts, and working out exactly what the obligations of the company is in relation to complying with those contracts if any external appointment was made. Additionally, the secured creditor could also get those contracts reviewed by various legal advisors to ensure that everything is above board. The second question that we have got is, in what circumstances would a secured creditor contemplate the appointment of a voluntary administrator and a receiver? I think off the top of my head, there's probably a number of circumstances that one would contemplate, but the one that immediately springs to mind for a secured creditor is that voluntary administrators have the benefit of a moratorium period which prevents charge holders from enforcing their charge unless they have a charge over the whole or substantially the whole of the assets of a company. So what that means is that in circumstances where you might have a business that has lots of different pieces of hire purchased equipment or financed equipment, it may be beneficial for a secured creditor who's looking to enforce their charge to appoint both a receiver, so they have the benefit of having the receiver realise those particular assets, and also a voluntary administrator so that they have the benefit of that moratorium period. Okay, well that's all we have today. So unless there's any other questions, I'll hand you over to Kieran. Thank you very much for attending.
Thank you, Leona. That was a very informative presentation with some great hypotheticals. That brings us to the end of the webinar today. We hope you all enjoyed it. Thank you for listening. We will be posting a full recording of this webinar to our website, www.lavanlegal.com.au. And a link will also be emailed to everyone in the next week or so. Thank you again for participating today, and we hope that you will join us again in the future.